between gender, climate change, and justice challenges and the way forward. Then we had session 6, which basically dealt on the theme of justice and climate governance. Then we had session 7, which was on alternative justice system and caseload management in the environment and land court. So from the outline of those discussions and the headings and themes of these sessions, you realize that we moved slowly from the general to the very specific on issues of climate change and climate justice. And very important points came across. And again, I may not do justice for all the points that were discussed during these various sessions, but I'm just going to highlight the main and emerging points, and which I believe will form part of the final communique that we'll read sometime this afternoon as the agenda and plan of action from the 3 days meeting here at Moi University. So from these sessions and the high-level panel, the issue of partnerships and fostering collaboration in climate financing obligations and processes generally, governance and justice, that collaborations and partnerships are very important in carrying forward. What also came out is that the judiciary has a very core and specific role in climate financing, and basically ensuring that there is just transition. There is accountability, there is fairness, there is justice, and that we have fair outcomes in climate financing. We were also told that in the frameworks for climate financing, there are actually inbuilt mechanisms to ensure local ownership of the processes of climate financing, and we were explained to various ways in which ordinary members of the public, communities, individuals are involved in these financing arrangements. We were also informed of the potential investments in energy, including the nuclear energy options, but we were also alerted of the risks inherent in this, and there's a need to balance rights, information, awareness in such investments. The community level funding mechanisms and alternative livelihoods for adaptation, building resilience, and all that are in place and ongoing, and there is emerging evidence of impact despite the challenges, but there is gradual and progressive improvement. Very important, we were informed that climate justice, adaptation, resilience, mitigation, and all that can only happen in a climate of peace, and where we have a stable environment where there is inclusion, there is diversity, and peacemaking. Peace and climate governance will thrive. Public awareness information is critical for just transition, because the voices of the public need to be heard, and decision. Therefore, information, awareness creation, and all that is critical to the transition that we seek. With regard to alternative justice systems, it's not actually a plan. It's already a strategy of caseload management. It's already a strategy of caseload management in the ELC, the adjudication method by courts. Gender justice and gender justice in climate governance was mentioned, and it's important that the women and girls are included in just transition for effectiveness and sustainability. Effectiveness and sustainability. Capacity building was emphasized. Capacity building was emphasized in relevant areas for the court and beyond, in relevant areas for the court and beyond court, all in order to have adequate responses to challenges related to climate justice, and engage in pro bono and access to justice and promoting that just transition. Specific sectors were discussed. We had sports, agriculture, and technology and others. And in all this, there was emphasis that we should have a multi-sector collaboration, multi-sector approach in order to ensure that there is a holistic, holistic transformation that we seek. And that it's broad-based and it affects all the major public sectors of service delivery. And the issue of investments in climate change, climate justice, carbon trade, and all that, it was mentioned as a potential for achieving the distributive part of justice. But we also cautioned to be careful and look at exploitative trends, address them through regulatory frameworks, and ensure that there is genuine distributive benefit. And I think I've mentioned this earlier, but it's the last point: climate governance, development of specific frameworks to assist in those outcomes is important, and there were specific commitments to ensure that we have a relevant framework in place, because this will ensure public ownership of climate justice and terms. Those are the discussions that we had yesterday in the 4 breakout sessions and the high-level panel in the morning, and I believe they set a firm basis for the final discussions today and the resolutions later. Thank you very much.
Very well. Indeed, they set the pace for the day. If you look at all those points, that sets a good pace for us to close, but close well, I think. When you discuss or you talk about partnerships and collaboration, I think it came even from the first day and the discussions we had on the first day. You cannot live without partnerships. I know this is how the courts operate, but you cannot live without partnerships. And remember also on day one, the proposal that was also given by CPF, on source revenue raising by CPF, on source revenue raising, resource mobilization. We must do that, and we cannot do that if we don't have partnerships. Climate financing, a big thing, running from day one and day two, and I'm sure again it must come up today. Localization. It's a global term that is trickling down easily and very well to local solutions. How do we apply local solutions in global conversations? Peace and justice, access to information, public participation, gender justice, climate governance, all these are critical issues. If you talk about capacity building, it is continuous. We cannot be removed from the fact that we must always get our own judiciary, and of course, this court always refreshed. Access to justice. And what is also key for me, which is also coming up as a new item, is how do we ensure we embrace sexual approaches in our adjudication, in providing and facilitating a justice system, a just system. And with this, I think, allow me to invite Honorable Justice Anthony Obwayo, I hope he's here, to take us to the next session. And this, I think, is the last high-level session that we have, so that we have all these things packaged, and you take us through the role of the judiciary in climate justice, in environmental justice. I hope that your panel can actually take us through that. I leave it to you to guide us. Thank you.
Good morning, Principal Judge, judges, and participants. Welcome to this session. And we have discussants that are invited to the podium. We have Lady Justice Mary Mbote, a non-scholar. She will come to the podium. And we have an advocate of the High Court of Kenya, Ms. Ruth Okara Namati. She also come to the podium. And we also have Commissioner, National Land Commission, Gertrude Duku. So before we start, my name is Anthony Otengo Ombwai. I'm the presiding judge, Environment and Land Court, Nakuru. I'm also a founder of a conservancy known as Ambururu Conservancy. If you Google in your phones, you'll find that when they were talking about the Garden of Eden, I thought about that conservancy. Instead of plucking fruits from we have been adding fruits. Most of these judges have planted trees at that place. So to start us off, today's theme is developing sound jurisprudence on climate justice in Kenya. In Kenya, through formal court cases and sometimes through informal processes. You know that environmental litigation has increased. It increased initially after the enactment of MCA in 1999. And also after the promulgation of the Constitution of Kenya 2010, which places a lot of importance in the right to life. And you know, the right to life encompasses the right to a clean and healthy environment. In this discussion, we will hear from the discussants, especially to begin with, Lady Justice Jane Onyango, on issues such as matters that have been determined by the court to promote climate justice. I'll come to the question later. And from Professor Kameri Mbote, we know that UNEP provides evidence-based data to inform policy decisions, collaborations with sectors of low carbon transition, and provides climate finance mechanism and aids to countries. And to Ms. Ruth Okara, we have heard that very few cases that touch on climate justice and generally environment. So we will hear from you and from the Commission Gertrude Duku on the role that is played by the National Land Commission in climate justice, sustainable land use, human rights, and inclusive development. Did I leave out one discussant That is Dr. Nyaberi Tipo. Is he with us? Dr. Nyaberi Tipo. He has not arrived. So we'll go straight to Justice Jane Onyango. And the question to Lady Justice Jane Onyango is, what is the role of the judiciary in combating climate change? And what must the judiciary address climate justice? Welcome, Justice Jane Onyango.
Good morning, and thank you, Chair. Good morning, everyone, and thank you for this opportunity. As you all know, the judiciary has a very key role in adjudicating cases to do with environment and climate change. We have the mandate as a court, the Environment and Land Court, having been created pursuant to Article 162 2B of the Constitution, which provided for the establishment of the Environment and Land Court and an Act of Parliament. Our mandate is cut out in that statute. The cases that we are supposed to deal with are stipulated under Section 13 of the Act. And we deal with a wide range of cases, touching on land use, touching on issues of title, and occupation to land. And specifically touching on environmental matters and climate, it's put as climate issues. At that time, I think this whole discourse on climate change was not that, it was not as highly discussed as it is now. So at the time the act was put in place, they just put it as climate issues. But now we know that climate issues also mean dealing with issues to do with climate change. So our role is adjudicatory in nature. We listen to the cases that are brought before us. Having created two divisions of the court, that's the land and planning, the land division and the environment and planning division, we are now able to separate these cases and know that this case relates to environmental issues, planning issues, while this other one relates purely to matters of occupation, title, and use of land. So when it comes to environmental issues, is to ensure that the benefits and burdens that we've been talking about since Tuesday are shared equitably. And when we talk about the benefits, we are talking about things to do with clean air, clean water, biodiversity, how to ensure that we conserve our forests, for instance, things like that. And when we talk about the burdens, then those are the benefits. Then the burdens will be the opposite. We'll be talking about poor quality air, pollution issues. Our rivers are highly polluted now, and things like that. So it's our role when cases of this kind are brought to us to look at what the issues are. If we need to consult experts, we call in experts to give us, their expert reports on on issues like pollution, the levels of pollution in a river. If it's something to do, if somebody is claiming that perhaps they are claiming, say, compensation pursuant to the effects of climate change, we will need to go into issues of attribution. We'll need to know, is this an issue that was created because of climate change, or is it just human activity? So those are things that as judges we must look into. Of course, bearing in mind the legal framework that we have, the acts that have been put in place, the statutes in Kenya, as well as the international legal framework, the instruments that Kenya has signed. They may not be persuasive, but they give us guidelines on what we need to look into and how to interpret this in every particular case, so that at the end of it, what we come out with is a judgment informed not just by what we know from our own local perspective, but informed by what we have at the international level, at the regional level, as well as the national laws that we have in place. So that is one role of a judge, the adjudication of cases. And I know a lot of us here have dealt with matters, not specifically that have been filed yet, but we anticipate that they will be coming because of the awareness that is being created in forums such as this one. But I know that a lot of us have dealt with issues to do with, say, the right to a clean and healthy environment. There are many, many cases that have been filed. I could give examples, but I know almost each one of us as a judge has had to deal with such cases that have been brought before us. So it's a right in the Constitution. What does the Constitution say about the right to a health and clean environment? What does it entail? What does Article 69, Article 42 say about this right? And how do we interpret it in the particular circumstances of a case that is brought before us? Then the other role that we have as judges is to also refer cases for mediation. Yesterday in the afternoon, we talked about AJS, alternative justice systems. So in matters where we feel that perhaps resolved in a forum other than the court, then we do refer those cases to mediators to deal with the issue. And an example was given on maybe in future, we may have to refer cases to do with carbon credits, where communities are now having to grow trees and they are paid if there's a disagreement over that, and we feel that perhaps that is a matter that needs to go to AJS, then we would refer that. And then just to explain that even in our judgments, what we do is to break down these laws, break down these international legal instruments for anyone reading that judgment to understand why we have reached a decision on an issue. If it's an issue where perhaps the question of public participation has been brought up and there's a complaint that perhaps a decision was reached without involving a particular group of people, that will have to be explained that this is the reason why we are saying there was no public participation. So when we talk about jurisprudence, it should be the jurisprudence that anyone who is not a lawyer reading should be able to get the interpretation of the laws through your judgment. It's said that judges speak through their judgment. So you're supposed to explain it in such a way that anybody, either a scholar or even the litigants themselves, are able to understand why that decision was reached. And sometimes we say that even if you lose a case, but you are able to read and the explanation through that judgment, then you'll be satisfied with it. It is possible to be satisfied because you'll then get to understand why that particular decision was reached. The other role that we play as judges is in capacity building. Capacity building either with other institutions or we ourselves also need to undergo a lot of capacity building when it comes to issues of climate change. We interact with other judges from other jurisdictions. We learn from them. We get to know what kind of cases they are dealing with so that we can see how these particular cases can apply in our particular situations. Because we have to be, broad-minded. We don't just restrict ourselves to what we have in terms of our own laws. We also want to know what are the trends in this particular area, what are the other jurisdictions saying, how can we interpret the laws in an innovative way so that we achieve both distributive and procedural justice. We have to look at issues to do with the marginalized, issues to do with gender, issues to do with children, so that we see how to incorporate all these issues in our judgments. I would like to stop there for now.
Thank you. The next discussant is Professor Kameri Mbote. Sorry for referring to you as a doctor. I confirm you are a professor. You are our teacher when we were at the university, and we respect you. So the question is, how can UNEP utilize the experience of the Kenyan judiciary to impact the judiciary in Africa to influence climate change justice?
Thank you. I being called doctor because I am a doctor as well. And if you know what a doctorate takes, you spend many hours a week. So professor, yes, but also doctor. So that is really not a big problem. But this whole issue of what UNEP can learn from what the judiciary in Kenya is doing, I think I'd like to begin from the point of what do we do as UNEP Law Division. First of all, to say that when UNEP was established in 1972, one of the foundational mandates was development of environmental law. And this mandate of development of environmental law has grown. And now we have developed a concept called environmental rule of law. An environmental rule of law is what we are talking about here: substantive, procedural, and distributive justice. Basically applying the tenets of the conventional rule of law to the environment space. And to do this, we have a vehicle, and the vehicle is the Montevideo Program for the Development and Implementation of Environmental Law, which is a 5-year program initiated in 1982, usually from 82 to 92. Right now we are on the 5th iteration, Montevideo 5, which was concluded in 2019 and goes on until 2029. And within that program, we work with different stakeholders. We work with parliamentarians, we work with lawyers, we work with judges. UNEP has a very vibrant judicial program. The Global Judicial Institute for the Environment, and the judiciary in Kenya is represented on the steering committee of that institute. But what we keep seeing is development of new environmental courts and tribunals. Before, it was felt that environmental issues could be addressed as just any other issues. But now, the currency of specialized environmental courts and tribunals has gained traction. And I think the environment at UNEP, again, we do track the development of environmental courts and tribunals. It's interesting to note that we are having mushrooming of these courts. It was interesting, I think the principal judge mentioned that he was in China, and when we visited China, it is amazing to see that China alone has 2,000 environmental courts and tribunals. Of course, population and scale is an issue. But those courts and tribunals are popularizing the environmental rule of law. And we also track what kinds of cases are coming. In this regard, with regard to climate change, we publish a climate litigation report. And the last one we published was in 2023. And the next one will be in 2026. And what we see is growing jurisprudence. And some cases from Kenya have actually found their pride of place in the global litigation report. The other thing that in Kenya is the jurisprudence on the right to a clean, healthy, and sustainable environment. When the United Nations General Assembly passed the resolution 76/300 in 2022 on the right to a clean, healthy, and sustainable environment, people wondered what was new and different. But what was new and different was having the world come together and say, this is important. And the reason that happened is because countries like Kenya already had the right to a clean, healthy, and sustainable environment in the Environment Management and Coordination Act 1999. We have it in the Constitution. So one of the things that we noted was already there were 156 countries that already had the right to a clean, healthy, and sustainable environment. Kenya was one of those. So what the international community was doing was validating what we had already seen with happening in jurisdictions like Kenya. And here again, we have very, very robust jurisprudence, which started even before the Constitution recognized the right to a clean, healthy, and sustainable environment. What else can we learn? I think we can learn the state of continuous learning. I have heard that the Environment and Land Court is probably one of the courts that has a lot, and looking at what kind of capacity building we need. In fact, the establishment of the two divisions is also something that the world can learn. Because I think when we talk about environment, sometimes we forget that environment is a land. Property as land has a big role to play in environment, more important. So the whole question of determining what actions that you take with regard to land. These periodic meetings that the Environment and Land Court is critical because it is both an instance of peer learning as well as getting inputs from others. And the other thing we can learn, I think, is devolution, because when you must also begin to look at subnational. And I think in Kenya, that we see happening. We can also learn from Kenya question of The African Charter on Human and People's Rights was actually the very first instrument that recognized. Surprising that countries like Kenya have these in their constitution. We can learn how to institutionalize the substantive and procedural rights as has happened. We've been talking a lot about gender, and I think we don't speak enough about the protocol to the African Charter, the protocol on the rights of women. And the protocol on the rights of women, I think it's also called the Maputo Protocol, is, and I can say this from a point of knowledge, it is even more robust than the UN Convention on the Elimination of All Forms of Discrimination Against Women. If you look at the Maputo Protocol, it has development, right to food, right to water. And if you look at the global convention, CEDAW, it only has one on rural women. So what the Maputo Protocol has done is to break down these rights. And maybe that is why we hear a lot about the rights of women. We are also seeing quite a lot of discussions on rights of indigenous peoples that the Endorois took to the African court and the decisions made there. You can see, and of course, even as the Ogiek were going to the regional court, there had been very many litigations around their rights in different courts, and it is taking to get the rights of indigenous peoples implemented. So in essence, learning doesn't just happen from, say, the United States and with the environmental thing, because environment is at the local level. Environment is at the local level. Environment is not at the UN. It is with at the UN. It is with the people. Land. When you talk about restoration of landscapes, it is people. When you talk about limiting or minimizing greenhouse gases, whether the
mineral resources that the state has a right to. But when it comes to carbon and the carbon that is stored on community land, how should it be dealt with? Is it the resource that belongs to the state, or does it belong to the communities? Because you find that there's quite a distinction in how the carbon in private land is dealt with, how it's taxed. The benefits go directly to the private owner, but when it comes to community land, there's a distinction. So by and by, we made sure that some of these things have been included, and we're grateful for that, but there are certain gaps that might emerge that I'll talk about. Something that is also very crucial for us as we work with communities to strengthen their capacity, they have new local governance structures introduced by the Community Land Act, and in specific committees and the community assemblies. I believe when this law was being passed, and Commissioner is here, she will talk about it further. We wanted to really center governance such that they can make decisions on their own, they can enter into contracts, they have capacity to, the right to say no. So once you train them, for what they want, then we have better outcomes for them. But these have not come without its challenges. As Namati, I said, we also convene grassroots justice networks, and we have like-minded CSOs and people push for justice outcomes. And this is called the Grassroots Justice Network, that any of you can become part of. It's free. As we reflected on these laws and these projects that are imagined, being a nature-based solution to climate change, and seek to, so to speak, compensate or protect in the global south, what do we think about as the Grassroots Justice Network? You will find that some CSOs are against, because they're seen as perhaps, too land is being grabbed. Some are seeing these things as, a greenwash projects where, you can continue polluting as much as you can as long as you have, a carbon credit, which is a license to buy, a carbon credit. You can continue doing what you want. But others really think that this is an avenue for communities to get fair compensation for how they are and biodiversity. So along this perspectives, we've managed to come up with some principles that can guide the courts whenever you come up with jurisprudence on carbon justice. And one of them is you don't pay to pollute. We are here to advocate that not everyone should participate in these carbon markets, because right now, if the global average surface temperatures go beyond 2 degrees, gone. It's really gone. Some just damage control. But if we agree to have everyone participate in these carbon markets, then our planet is gone. Another thing is that we have to make sure that customary tenure rights of land are protected and recognized. Otherwise, you'll have a lot of land grabs, and the fears that people have in many instances over what consent should also be a place we can protect our communities from just entering into contracts where they have no idea about and they have no agency to decide how to make sure that whatever intentions they have as investors protect and respect communities. Fair participation is also another principle. This means that before you enter into a contract, as communities, do you have independent advice, legal advice that can guide you into what you're signing into? If a contract spans 30 years, how does it affect access to your land and use of it? And such things. Another thing, if you're to fairly participate in a market, you need the information. Not to be told you'll only be given at least 40% of the aggregate earnings when you really don't know what the total earnings are. A lot of these contracts have NDA clauses, where you're not supposed to disclose this because you have an investor, you have a financier, you have a broker, you have the audit, you have the standard, such as Vera. So you have to have all this information to fairly participate. And fair compensation is also another principle. If you're being stopped and the value of land has not been taken into consideration, because if you're just talking about the carbon, at least 50% of the gross revenue of these projects. And lastly, there must be enforcement. So we think that if jurisprudence reflects some of this, carbon be a good place to start. I'll just briefly touch again on what litigation we expect to come. I think if we continue without including communities in these discussions, particularly when it comes to drafting some of these laws, there's expected that there will be a lot of litigation around that, especially when the laws fail to speak to the needs of the communities. The term carbon rights has not been defined in any legislation, not in the regulations, not in the Climate Change Act, and definitely not in the MCA, which was passed earlier on. So litigation around defining those things will come out. Again, just if you define these rights, then who owns this carbon? And should it be treated the same way for private land and for community land? Why should community land carbon require a community development agreement between the investor and the community, whilst private land does not require the same? So many questions come up. Some definitions around benefit sharing also will come up because the Act talks about, at least 40% of the aggregate earnings of the prior year will go to land-based carbon projects, will be taken to the community. But when you read the regulations, it says that those benefits will be net of costs of doing business, which have not been defined. So that's something that is still a gray area and expected to come to court. Another thing that I think in theory, some things are quite simple. Well, when you think about it, what is capacity for contracting? We know capacity has a meaning when it comes to individuals and companies and other legal entities. But for these communities, what is capacity for them? Is it when they have the certificate of registration as communities, or is it when they have a title to land as communities? So that is something that is quite sensitive and will occur with time because of the money that comes in, and because of the nature of this project. We said they span quite vast areas and the money is big. I think another thing, I'll talk about quorum in making decisions around investments in community land. The Community Land Act says that you need 2/3 of the community assembly to agree to enter into any investment. 2/3 of 2/3. So I'm thinking about a community with 3,000 members, and that means for you to have quorum to discuss any investment, you need 1,000 people. When I think about it, and with the communities I'm talking about, it is very hard to even have a convening of 200 people. So that is something that will definitely come to court, and it will also discuss about how consent was obtained. Can it be obtained incrementally, where communities can sit in, discuss these things, and then give their consent, and then it can be collated to form?
Thinking about the expected litigation in climate change, when you look at Lake Nakuru, because of the rains that have occurred, the water level has risen. And most of the acacia trees, if you got, most of the acacia trees have been submerged. And that's the home of the baboons. Now, the baboons have left the park and they have come to the estates. They have invaded the estates around the park, and it has become a very serious issue in Nakuru. I expect somebody to go to court, file a suit, maybe against KWS compensation because of that migration. And it's a serious issue. Concerned is Commissioner Gertrude Nguku, and I want to thank you for accepting the invitation on short notice, and I'm happy about that. So the question is, which role does the National Land Commission play in climate justice, sustainable land use, human rights?
Thank you, my Lord, and thank you for me this chance to have this discussion with you. I don't know whether Professor Collins Odote is in the room. I've always gone there and talked with him and the Dean about how important it is to have these discussions in a venue like this. Because when it comes to some discussions, it's only the universities where we can have these discussions in an innovative, creative, and open way. And thank you, my lords and late justices, for your presence here and for making this discussion of climate justice possible, because we also resort to the court when it comes to the distinction of different some decisions which have been very important and which have made our role able to be performed. Now, let me start by anchoring the role of the Commission on the meaning of land, who owns the land, and the role of government in this land. Because this will give us a view of what we should anchor and what we should focus on. Now, according to the Constitution, our new Constitution, land does not belong to the county. Land does not belong to the government. Land belongs to the people of Kenya, collectively, as communities, as a nation, and individually. That is in our Constitution. That is who owns the land in Kenya. Now, with that context, then, what is land? And land includes even the air. It includes all the natural resources on the surface and beneath. Sometimes we seem to forget that and focus on land as just what we are stepping on, but it includes all these other natural resources. And then let me come to the role of the commission in this context. All independent commissions, they are supposed to be independent, is to ensure compliance of the roles of the national and county government, compliance of the values of the Constitution when they are exercising their role as delegated institutions for the service of the owners of the land, and that is the people of Kenya. Now, when I look at Article 60, it sums up everything we have been discussing here this week about climate justice. It anchors all the issues that we have been raising, and those are the issues which are defined by our land principles, and they are the principles that the National Land Commission has been set up to ensure that they are complied with. And these issues include the equitable access to land, security rights, protection of ecologically sensitive areas, sustainable and productive use of our land resources, and ensuring that there is no discrimination of gender. And also, it also includes that we use our community initiatives to resolve disputes. And that is all that has been captured and discussed this week here. It is the role of the Commission, first of all, according to Section 6, subsection 2C of the National Land Commission Act, to ensure that it does everything within its power to ensure compliance of national and county government in following these principles, and also to ensure that everything is done to ensure that there's this compliance. Secondly, it is the role of the Commission to recommend to the national government this national land policy, which ensures compliance of these principles, because these principles, according to Article 60, subsection 2, they are to be implemented through a national land policy. Now, recently, and that is last year, the National Land Commission made a recommendation of the national land policy. You know, the current one is the one we use, which is the one of 2009. And I'm happy to report that in their recommendation, they captured the issues of climate justice, and that is, they captured the need for the national government to include climate change mitigation and adaptation imperatives into land management practices to secure national short, medium, and long-term development objectives. On the other hand, NLC emphasized the need for natural resource management, use and conservation mechanisms that secure socio-economic well-being as well as ecological and resilient development. And I'm happy to report that in the draft new national land policy, this has been captured. The other role of the Commission is to ensure that they manage and administer public land. Now, what does this entail in the context of climate justice? Management of land means coming up with mechanisms and goals of development which are anchored on our national land policy and the principles which are articulated. Now, we can see evolving policies of government, some of which we are involved in, so rely on the law. Just to put this in context, when it comes to land management, that is why you'll find that all the ministries will seek consent when they are dealing with issues of land, including in forestry, wildlife, water, and carbon credit related activities to ensure sustainability, productivity, equality, and equitability exploitation of public land. And this advice is usually given by the Commission. Now, we also rely, of course, in the context of what we are discussing here, on MCA, which emphasizes the need of the national environmental policies to be integrated in all our development programs and projects. We also consider that the issues of poverty, economic development are to be factored into environmental initiatives of mitigation. So the two have to go together, and we have to consider that when we are giving this kind of advice to the various ministries according to the Forest Act, because that is the role we have been given. Now, in administration of public land, let me just contextualize this. Now, when we talk about administration of land, you have heard these battles about this is private, this is public, and so forth. But then administration of land is about determination, updating, recording, dissemination of information concerning value, ownership, and user rights. Now, if you look at that context, it means that the Commission has the role of interrogating the conversion of land to ensure that that land was actually converted the way it should have been converted. Now, the fact that somebody has a title to riparian land, they cannot shake that title and say, this is private land, so the Commission has no say on this. How did you arrive in having the title to the riparian land? Was it procedural? Now that is the role of the Commission. To look at, was this public land converted in a legal way? Now, of course, there are many other roles the Commission has. I cannot go into details. I just want to summarize some of the leverages the Commission can use in the issue of climate justice, especially when it interfaces several actors, and especially the judiciary. The Commission can leverage on its constitutional research mandate. It can leverage on its mandate to ensure that it encourages traditional dispute resolution mechanism. It can leverage on its mandate in comprehensive registration advisory to the national government. It can leverage on its constitutional mandate of planning oversight and valuation. And it can also leverage on many other legislative roles, which includes the fact that it is able to co-opt experts during their inquiries, and we have done so. It can also leverage on the fact that it has the constitutional role to institute suit, to defend suit in issues which concern land administration and management, including climate justice. It can also lobby for legislation and come up with draft legislation for Parliament where there is gap in issues even of climate justice. And it can also ensure that it has a budget that speaks to equality and issues of gender mainstreaming. Now, I'll just give 7 very, very quick examples of how this has been done and it can be done. First, let's consider the issue of research. I invite each one of us to go beyond just getting a few green jobs. For example, I attended with my colleague here, Ms. Okara, a very successful community summit in Isiolo recently, which they funded and organized. It happens every year, and it's actually regional, including Congo, Uganda, Tanzania, Rwanda, Ethiopia, and our communities in Kenya, and different actors and ministries and PSS. Now, in this forum, what we discussed and what I emphasized, and I will emphasize today, because I find it very sad that you can have a conservancy. I don't want to name which one. And this community member was presenting how they have gained by tumepata miradi tofauti. That is the opportunity they have gained from this conservancy. To have some people hired as watchmen, to have some plans to this land, and they don't have. And it's their land. It is their community land. So when we are talking of research, I want us also to think something which actually happened right here in our country last year and demystify the question. Now, $220 million credit is the largest auctioneer which has ever taken place in the world. And it took place in Nairobi during the climate conference. Now, what was South Africa and Egypt and the cookstop cooking mechanisms in Rwanda and Kenya, and who bought of incentivizing their companies in their countries they have got to, and who was doing the auctioneer? It was a very young lady. Combining all these facts, in research, we can do research, and I am emphasizing this because we are in a learning institution, we are in a university. We can do research to ensure that our young generation, who are very technological savvy, can be equipped, can be carbon market. What are the jobs of the auctioneer, the negotiator? Rate these standards that we are looking for. And a university like this can do that. We are talking about research where we can talk about in technology, in market financing, in agriculture, in forestry, and I can go on and on. The other example I want to give is the example of the interface of a task force of the government, conservation of the Mau complex, and come up with a very good task force about the settlement of the Ogiek in 2009. It had never been implemented. But the courts took this up, and Justice Namweya in 2014 came up with a decision to ensure that these Ogiek who had been forcefully evicted from the land where they were supposed to be settled, following that government task force report. Okay. I have to summarize. I have a few cases. I will really make it very brief for each one of them, that they could be settled back. So the commission was given the responsibility to carry out inquiries, identify, come up with a register, and resettle them. The second case I want to give is something I was involved in very recently. We conceptualized this land sea planning and guidelines for the 5 counties of Mombasa. And last week we went for the validation and sustainable management and development of activation, and providing financing for what is important and the roles which need to be done by the different actors, and also equitable stakeholder collaborations and sustainable allocation of the land. Now, I think my time is up. I would have given 1 or 2 other cases, but what I want to just summarize is this. Our role includes carrying out inquiries in our own initiatives to ensure there is climate justice and that different rights have been catered for, and also it includes coming up with inquiries as directed by the courts and filing back these different kinds of decisions that we have made to ensure enforceability. Thank you.
Okay, let's give all the discussants an environmental applause for what they have done. You know what an environmental applause is? You don't make noise. You just do like this. That's environmental, so that you don't scare the animals around you. Now, we have 18 minutes for discussion now from all the contestants. I will give each row one opportunity to ask a question. I'll start with the
5 more minutes from Commissioner Gertrude regarding the climate change conference. And she spoke about a young lady being in the middle of the auction. I wanted to know what was the relevance, or what more can you tell us about that auction? Thank you.
Okay, this second row. Make your questions short. You can also give a comment.
Thank you, Chairman. My name is Dixon Kidinji, carbon specialist. I'm happy because of the bench, the judges. They have done quite well. And mine is a recommendation. Now that we have the Climate Change Amendment Bill of 2023 and the regulation out, please help us clarify the whole issue of benefit sharing. This is still a gray area, and our communities will still continue suffering. They will continue being taken advantage of. So if you're able to clarify and simplify what this soil carbon means to the community, what tree planting means to them, it will be of very great help to our communities. Thank you.
The second last row, there's the gentleman there.
My name is Washira Kariuki, and I want to ask Commissioner, now that we are talking about climate justice, there is a lot of connection between historical injustices and how are they affecting the climate justice of the communities who suffer those historical injustices.
The gentleman ahead of you.
Thank you. My name is Nicholas Lagat. I am the Secretary General Paraboli Kenya. My question goes to the representative National Land Commission with regards the climate change. Say, for instance, that I have a title deed, and this deed extends to a riparian zone. And as the climate escalates, the river keeps also encroaching towards the land that I have the title. What will your interrogation inform in future with the title that I am entitled to vis-a-vis the climate change encroachment? Thank you.
The last row. Judge Kosibor.
Thank you very much. Thank you for those very good remarks. Usually I say mimi ni jaji wa Samburu na Wazungu. Now I'm excited to hear the discussions around community land. And Ruth, I'm not too sure I got the second name, nitakuona nyuma ya tent. So between Ruth and of course Prof can weigh in, Ruth and Commissioner Nguku, I heard you mention speak to the issue of community land and registration. My question is, do we know the extent of each community's land? Now I'm speaking from Samburu and Laikipia counties. You find different communities there, and you find different, of course, conservancies is a story that we should discuss under the cover of darkness, but let me limit myself to the communities. So would you know where the land for, let me give, Ilingwesi community would end and where the next one would start? Further than that, you get to a county like Samburu County. Samburu County is not inhabited by Samburus only. It also has Turkanas. So there is Turkana occupation of a place called Baragoi. You know, those of you who are not pastoralists, you might not know in what direction Baragoi is. So Baragoi, one side of the road has Samburus and the other side has Turkanas. Do you know how far the Samburu land of the specific community that would be living there? So the community, do you know how far their land would be? And the other one for the Turkanas on the other side. So that when the government comes in and it's supposed to acquire land for public purposes, which community is it going to deal with? Before we even talk about registration so that you can safeguard the rights of my good Samburu people and my Turkana people in northern Kenya, do we know how far their land goes? That's question number one. Number two is food for thought. I did a case in Laikipia, Nanyuki, involving community land. And the main complaint was that some aspects, okay, it was partly an environmental matter. And the issue was that the community leaders, without the participation of the community, had gone ahead and given away the community's land. And whatever the people, the investors were given the land for, had been put up, somehow they had sought the approval of NEMA. And NEMA said it had published the approval in the Kenya Gazette and in 2 newspapers of nationwide circulation, and they were raising a preliminary objection. And then I had to ask this question: do you think my good Samburu people from Ilingwesi would have an opportunity to read the Kenya Gazette to know that NEMA has given approval for the land which has seasonal streams that would serve the whole community during the dry spells, have been given away, and they're supposed to be handled by investors for the next 50 years, exclusively without the community? So would they know about the Kenya Gazette? Secondly, are they expected to read?
I don't know how NEMA came into this, but I want to find out for the 4th schedule of the Constitution, one of the roles of the counties is to ensure there is community public participation. It's actually specifically spelled out, and that's the role of the counties. On the issue of Igwesi, I remember I represented the chair in giving the first titles, and I remember really getting very worried and bringing it up in that event. Planning should have been carried out before the transition from group ranch to community land. I'm trying to be very fast. On the issue of auction, somebody asked about the young lady. This is the voluntary carbon market. We know that there is no binding international norms on the issues of the Paris Agreement, and not just Kenya, but many other countries will be dealing with this. We know the recent decision of the Uganda decision in Netherlands recently, which was dealing with this, and the judges came up with something which I wanted to make as my final shot, and I will answer your question while I talk about it. It was raised by the representative IDLO yesterday. Even if we don't have binding norms for each country when it comes to this carbon credit and other issues of climate action, it is the responsibility of each country, and that is the responsibility of each one of us here in our different roles, to ensure protection of our own citizens from danger. And it can't, the countries cannot duck their responsibility. And so this was the voluntary markets. This young lady was coming up with a company to do this, and it is something we can all do. And actually, under the new carbon credit, somebody raised this question, and I want to merge them together. The Carbon Climate Change Amendment Act of 2023, it considers Section 2 of the Paris Agreement, that the Minister of Environment can enter into bilateral voluntary agreements and come up with ways of generating income. Singapore has done it, and we can do it. So it is up for grabs, and it's up for each country to take care of their own citizens when it comes to resilience of the environment and also to economic development by seizing these opportunities. On the question of benefit sharing, I'll point out to the fact that the new regulations of the carbon credit, which were gazetted this May, this year, there are some areas, and maybe Ruth, you look into it in public litigation if it comes up. There are some areas which are in contradiction with the Community Land Act, and legislation takes precedence. Judges know this. In particular, there are some things which the community actually has to be at the center of making their own contract. The other parties cannot make these contracts for them. Unfortunately, most of them have not been registered, and that is something maybe a public litigation case will maybe fast track. And if they are registered, it is the contract which dictates what is to be done about the cost sharing. And issues to be considered are all in Section 35 of the Community Land Act. They include royalties, they include compensation for the benefits. They include things like compensation for the land, compensation even for the negative effects when the contract is terminated. It includes what they benefit from this, and the Commission is supposed actually to come up with regulation of the Land Act about the benefits of the communities in places where they live, and they are still to be done. They are still to be funded for that. On climate, on the issue of injustices, the Commission is supposed to do not only historical injustice, but also present injustices, which includes the evolving climate injustices. We have admitted 1,007 cases. We have not been funded to do them. We usually have to go to donors to fund us to do them, but we do as much as we can. But enforcing becomes a problem. And we have been lobbying Parliament to come up with legislation, legislating our investigation. Thank you very much. President Agoto, you pointed this out when we were launching the guide, but we are still pushing for that. It has not been done. Because if we don't have teeth of enforcing our inquiries, or teeth even to call witnesses to give evidence, or teeth to be funded through, by legislating our investigation the way ESCC has legislated theirs, it's going to become very difficult to enforce our mandate. On the water which has risen, that is the role of the county when the water rises in enclosed places to come up with policies about this. And I don't know whether your county has done this. And for the judges, of course, there's the case of Mitubel, where they have come up with these structural interdicts about different actors, what they should do about cases of climate justice, and the jurisprudence is evolving around this area, which is very interesting. It's coming out of the courts. Lastly, on the issue of community land, does the Commission have a role? Yes, it has a very specific role under Section 24(1) of the Community Land Act, and this is the role of ensuring that land which has been lost by the communities, this regularization, and that it reverts back from this irregular private ownership back to the community. I can go into the wind power case, which are now going NTR, but I don't think I have time for that. You can see me behind the tent. Thank you.
Thank you so much for those questions. I think I will directly answer my sister from Samburu, where I also work with the communities there. It's a concern that since 2016, after the passage of the Community Land Act, we are still a long way away from having the land registered and communities receiving their title. There's been quite some progress for those lands which were previously group ranches. And now the Act was repealed, the Trust Lands Act was also repealed. Now we work with the Community Land Act. But yet there's still very low progress in making sure that particularly those which were formerly trust lands have transitioned. I think only 3 have transitioned into community land. So it brings about all these questions about what could the communities do. As CSOs, there's a lot of advocacy towards making sure that these lands have been protected, and registration is key in making sure of that. So it's incumbent and it's upon the counties to make sure that they submit the inventories. I think they were given 18 months by the Act, the passage of the Act. They're supposed to submit all inventories of unregistered land, because if land is not private or public, it is considered community land. That is yet to be done by many, many counties. I think the only county that has done 100% transition from group ranches into community land is Laikipia. And we thought the rest could borrow a leaf, but there's quite some challenge towards that. But advocacy efforts have been put there. I think just in my closing remarks, as we discuss about benefit sharing for nature-based climate solutions, I really want to run away from labeling communities as beneficiaries. They own these lands. They are custodians of the biodiversity. They are not beneficiaries. They should be primary stakeholders with agency to decide for themselves how they want to use their land, if they want those projects or not. Hence, the regime of mining should not really apply. And that is something that I think jurisprudence should reflect, perhaps when the time comes. Thank you so much.
I speak about this not as a UNEP official, but because I have a little knowledge of some of the issues that you asked about. And I think with the community land, it is, when you look at the history of land rights in this country, community land was never supposed to be a genus of land holding. And in fact, historically, the expectation was that community land rights would grow up and become private rights. And it is only because of the resilience of the community narratives on land rights that both the National Land Policy 2009 and the Constitution 2010 put in the rights of communities. We haven't had a long time implementing community land rights. And from a cursory observation, I think we go to community land management wearing the lenses of private land rights. And that is where we fail. Because community land is land that is enjoyed by different people at different times. And if you're looking at how we have even badly implemented private land rights, if we bring it to community land rights, we will mess community land rights. So in essence, the slicing, dicing of community land rights may not be the way to do it, and it may be very important to begin thinking of how to deal with these rights. I'd like to talk about benefit sharing also. Benefit sharing isn't only about carbon. Access, sustainable use, and benefit sharing was first discussed within the realm of biodiversity. But what happens is when a new resource is found, we think we have to come with new benefit sharing regimes. But at the end of the day, what we're talking about free, prior, informed consent, it cuts across. And then finally, this whole issue of the rights to carbon. You know, when I think about land rights, I wonder, why do we talk about land? If you think about your native tongues, what is land? We don't deal with soil, we deal with land. Yet, soil is really the thing of value on land. Whether you're talking about it being the one that grows crops or also the one that stores carbon. And then finally, there's somebody who was talking about the encroachment of rivers on people's lands. Is it the rivers encroaching or humans encroaching? And you know, this is an issue also that has arisen when you look at the rising sea levels. A lot of people who probably say, I own beach frontage land, act of God, it will now go back where it belongs. But you see, there are also small island states that may disappear. And the International Law Commission has been discussing the issue of boundaries. When an island disappears in the ocean, or when a big part of his land becomes ocean, what boundaries will we use? So I think that is also a place to look. But we're going to have a lot of these because of humans' unfettered and undisciplined use of land. Thank you.
I had no question, but just to say that as the Environment and Land Court, we see that there's a lot that's coming out in terms of the effects of climate change that are likely to come before us. And we need to start thinking of how to deal with all these questions. They are new, they are very interesting, and as a court we must be prepared to deal with them, to interpret the laws that have been put in place, and to apply the principles that guide us in interpreting matters, environment and climate change. And yeah, I think we need to continue this discussion, and hopefully we'll see more and more cases coming up, which we'll be able to see how to handle, and to hold the government accountable, and even the private sector, in terms of the effects of climate change and how it will affect the different sectors of the society.
Thank you. To add on that, we have riparian landowners who have riparian rights. So I believe that if the water body rises abnormally or unreasonably and takes up your land, you are entitled to some compensation unreasonably. Or if the water recedes unreasonably, you are entitled to the land that has been unreasonably. But the problem is that our water bodies are not marked. The rivers have not been marked. There's no survey that has been done to know the highest water level and the lowest water level. So that even if you went to court, you'll have a problem proving that that was the water level. Thank you. The Attorney General has an important question to ask, or a comment. I'll allow that question, then we'll go for the lunch break. But before that, we'll tea break. Oh, sorry, I think I'm not used to taking tea. Mr. Char, welcome.
Yeah, thank you so much, Chair of the session. My name is Trufosa Char. I'm a representative of the Attorney General in the forum. Before then, just a few months ago, I was in the State Department for Lands and Physical Planning. And good morning, Commissioner. So I was sitting here and I was just aching to just put things into perspective as far as implementation of community land is concerned. Hi, Namati. So to date, 59 communities have been registered under community land, those that have titles under community land. And among the 59, 11 of them are former trust land. We used to call them virgin lands. Okay, those that initially belongs to under the management of the local government authorities, those that were neither group ranches nor land that had already been adjudicated upon. So we have 11 of them, and then we have 48 community land titles that are former group ranches that were basically undissolved group ranches. So in Taita Taveta, we have 5 titles. In Kajiado, we have 2 titles. In Baringo, we have 2 titles. In Laikipia, we have 13 titles, community land titles to be specific. In Samburu, we have 25 community land titles. In West Pokot, we have 8 community land titles. And in Turkana, we have 3 community land titles. Having said that, I want to say that 71%, close to 68 to 70% of the total land mass in Kenya is community land. And so if we are looking at that in terms of climate change and the nexus between community land and climate change, then I think that is an area that we should leverage on. And then the other thing we should be asking ourselves, what is the nexus between secure land tenure and climate change? And how does it accrue to our grandmothers when it comes to the issue of carbon credits, the contracts we are talking about, and so on and so forth? So I wanted to put that into perspective. And I think something else that has been mentioned by the panel, Namati, and also the commission, is that how do we then relook at the proposed amendment in the Climate Change Act and have some connection with the Community Land Act, especially in relation to the governance structures that has already been established under the Community Land Act, especially when we want to find that nexus between secure land tenure and climate change. So I'll say those few remarks. For more discussion, we can have tea. Thank you.
So I would like to thank the discussants for their informative presentations. I also want to thank myself. And I will say that we give them
to know and to have that. Thank you, Professor Mbote, and thank you for staying. A lot of learning to do, I think. Our rapporteurs, I hope you'll capture that so that it goes into the reports. For us as ELC to learn from a lot of things I think I noted down, I don't want to repeat. And thank you for bringing that to the fore. Thank you, Judge, our judge from Eldoret, Onyango, and of course, our moderator. Can I now ask that we clap for them as they take their step down the podium? Let's do that until they sit. I think that was a very good session. And of course, thank you. Sorry I kept harassing you because of time. We would like to take some tea. We'll take only 10 minutes because I see we are at 11:12. If we take 10 minutes, that will take us to around 11:22. If we do that, I would like that we spend another 1 hour, 20 minutes to have the next 2 sessions. One will be here, then another will be in tent 2. Mheshimiwa? Oh, Dom. And where is your colleague? The other moderator? Ah, there. So those who's going to tent 2 will follow him. In the dome, we will follow the Honorable Justice Judge here. So let's take 10 minutes for tea. Ah, sorry. In the main dome with Justice Nzili, we have the theme, local, regional, and global judicial trends in climate change, litigation, and jurisprudence. So those ones who have an interest there, remain here. After tea, come back here. And then we have session 10, developing a framework on judicial capacity in adjudicating climate change cases. Ben Opa will be the moderator. Justice Angima will be our chair. and that will be intent 2. Is that okay now? So can we take tea for 10 minutes? Then let's have you back, please, so that we can save on time. Let's meet here at exactly 1 p.m. for 20 minutes of recap, and then we'll break for lunch. So our moderators, make sure we are here by exactly 1. Thank you.
Waliokosa kusoma wafanye kazi na nguvu, waambie watoto mwisho wa kusoma kweli furaha. Waliokosa kusoma wafanye kazi na nguvu, waambie watoto mwisho wa kusoma kweli furaha. Someni vijana, muongeze pia bidii, mwisho wa kusoma utapata kazi nzuri sana. Someni vijana, muongeze pia bidii, mwisho wa kusoma utapata kazi nzuri sana. Mambo ya siku hizi sikupigana mangumi, kalamu na karatasi ndiyo silaha ya siku hizi. Mambo ya siku hizi sikupigana mangumi, kalamu na karatasi ndiyo silaha ya siku hizi. Someni vijana, muongeze pia bidii, mwisho wa kusoma utapata kazi nzuri sana. Someni vijana, muongeze pia bidii, mwisho wa kusoma utapata kazi nzuri sana. Waliokosa kusoma wafanye kazi na nguvu, waambie watoto mwisho wa kusoma kweli furaha. Waliokosa kusoma wafanye kazi na nguvu, waambie watoto mwisho wa kusoma kweli furaha. Someni vijana, muongeze pia bidii, mwisho wa kusoma utapata kazi nzuri sana. Someni vijana, muongeze pia bidii, mwisho wa kusoma utapata kazi nzuri sana.
conference, the role of courts in remedying climate, a call for distribute and procedural justice. Taking School of Law in Eldoret from November 25th to 29th conference promises in Kenya's climate justice journey. Building on the ELC at 10 conference in Kilifi, government officials, civil society, and community leaders to deepen and foster collaboration on climate change and justice will explore critical themes including empowering women for grassroots climate resilience, climate justice for marginalized communities, climate action, biodiversity, and integrating into Kenya's food and agriculture systems. The Environment and Land Court stands as a beacon that justice is a reality for Kenya and beyond.
So for the panelists in the dome, kindly, so that we all can come in. Your chair is here, your moderator is here, we're waiting for you, the panelists. Justice Okongo, kindly.
That particular act also gives us jurisdiction to hear and determine disputes arising from a right to clean and healthy environment, which is a fundamental freedom in our act. In addition, the act gives us power to give several remedies We can give remedies of injunctions, prerogative orders. We can award damages, compensation, restitution, declaration, and all the rest. So in the same act, so that is as far as the Environment and Land Act is concerned, which is one of the main tools that we can use to develop robust jurisprudence in this area of climate change. But we also have a modern environmental law framework in the name of EMCA. That is EMCA 1999, that was amended in 2015. As we are all aware, EMCA confers on every person a right to a clean and healthy environment. And it gives standing to anyone who feels that that right to a healthy and clean environment has been violated. Again, like in the Environment and Land Court Act, EMCA also has the same guiding principles on environmental law, such as the principle of public participation, cultural and social principles applied by Kenyan communities in the management of the environment and natural resources, principle of international cooperation in management of shared resources, principle of intergenerational and intergenerational equity, and all that. And I would say, apart from EMCA and the Environment and Land Court Act, we also have the Constitution of Kenya 2010 that established the Environment and Land Court. Of course, the Constitution established a specialized court, which is the Environment and Land Court. But again, under Articles 22 and 70 of that Constitution, the rule on legal standing has been relaxed. And the Constitution, if you look at Article 69, places some obligation on the government to ensure sustainable exploitation and conservation of the environment. Again, of course, Article 42 provides a right to a clean and healthy environment, but again, Article 70 of the Constitution it also provides for remedies that the court can give. It provides that when an application is made by such a person, the court may make an order or give directions that it considers appropriate to prevent, stop, or discontinue an act or omission that is harmful to the environment, compel a public officer to take measures to prevent or discontinue an act or omission that is harmful to the environment, or provide compensation to a victim of a violation relating to climate change and duties. So what I'm saying, in other words, is that we have a robust legislative framework anchored in our Constitution that we can use to develop a robust jurisprudence in this area of climate change. Moderator, just give me 1 minute to add one point. I know my time is up, but I want to mention that we are all aware that, again, under our Constitution, the Constitution provides that where Kenya is a signatory to any international convention or treaty, it becomes part of the laws of Kenya. And I know you know Kenya is a signatory to the United Nations Framework Convention on Climate Change, 1992, the Kyoto Protocol, and the Paris Agreement. So those are some of those international instruments that we can also use to anchor any jurisprudence we want to develop in this area of climate change. Thank you.
Thank you very much, my lord. Mr. Kemei, is he with us? Henry? For the LSK, he's not with us. Now, Benson, it takes two, both the bench and the bar, to tackle in matters jurisprudence. What is the state of bar's preparedness to undertake effective climate litigation in Kenya? And how can the situation be improved? Over to you. Your 4 minutes.
Thank you very much, Judge. I request that I stand here because part of the participants can't see me sitting down. I'll examine the question that has been asked about the state of litigation, climate change litigation in Kenya. And I must confess that this is ongoing work, part of work that the organization I work for, ILEG, has been doing over the last 2 or so years as part of a global initiative to examine the evolution of environmental jurisprudence, not just in Kenya, but worldwide. In terms of evolving jurisprudence on climate change litigation, I think for us, the first thing we want to ask is, what is climate change litigation? And the answer that I would give from this research is that it is still a mongrel. It is not yet fully defined what constitutes climate change litigation. And at a time when we are grappling with defining the pigeonholes within which we can bring environmental law cases to the Environment and Land Court, I think it is a relevant question that perhaps we should continue grappling with. Where do you file a so-called named climate change case? Because we have the two divisions, but we know that issues related to climate change relate to planning. They are overall environmental issues. They could even be criminal issues because many times some cases are against violation of standards. It could be as simple as cases that previously we considered to be climate change cases of somebody driving and emitting black smoke, which could easily be a traffic offense under the Traffic Act. They could be consumer protection for environment versus Ministry of Environment in India, where basically the tribunal commanded a certain manufacturing company not to produce certain products that they were producing, particularly chlorofluorocarbons. So basically, to conclude that bit, is that yes, there is climate change litigation with substantive issues relating to climate, but it is no much different from the grounding that we know of the environmental right, the right to a clean and healthy environment and the right to life. Now, mostly these environmental cases are seeking to enforce obligations of the government or commitments of the government to the population. In our case, this is best encapsulated in Article 69 of the Constitution, where we have state obligations on the environment. And therefore, this has been seen across the world. You know, I think I heard today that the case of Argenta case was discussed yesterday. I think maybe a presentation by IDLO. But this is basically a case in the Netherlands where the court was forcing the government or compelled the government to live up to its commitment to climate change and achieve certain standards, the 25% reduction commitment. Finally, Bwana Moderator, let me speak about remedies because I think it is very important. In most climate change litigation cases, in as much as we always want our judges to be proactive and to blaze the trail, caution is always called for. Why? Because the subject is diffuse. The science is still not exact, it is imprecise. So while you can always call on the precautionary principles and other well-established principles that have been mentioned, there is always need for caution in terms of provision of remedies. So you rarely would wish to declare a climate change act, for example, the 2016 one, as unconstitutional and therefore null and void, in as much as you also want to avoid cases where development is hindered simply on the basis that it would cause emissions, particularly in the absence of precise science or at least some degree of certainty on the outcome. Thank you very much.
Thank you very much, Benson. Now turning to Del Onyango. This is your question. How can and should CSOs private sector contribute towards developing and sustaining sound climate change jurisprudence in Kenya? Over to you. You have 4 minutes.
Thank you very much. Before I answer the question, let me just concur with my senior here that it's very important to understand what climate litigation is, and this is a hugely amorphous subject in Africa, and that is why if you look at the statistics, they say that Africa, the global south, only has about 114 filed cases. So I think the question that we might ask is, how do they define climate litigation? And these are conversations that we can have even beyond this. Back to the question that has been put to me. First and foremost, I work at Natural Justice, a Pan-African organization of lawyers and environmentalists, working in the intersect of environment and human rights. So in terms of speaking to what CSOs do to support climate litigation, I'll also draw reference from what we do as an organization, because we've done a lot of strategic litigation, both domestic in Kenya, at the East African Court, in South Africa, and in West Africa. The organization being a regional organization. So first and foremost, representing communities in court. That could be one of the main roles of a civil society organization. They can appear in person to represent communities, and it has been said, our Kenyan courts are very laxed on the issue of standing in court. So CSOs can as well come and present cases on behalf of community. A very important one is the ghost drafting of application. Ghost drafting of application is when someone else goes to court, but as civil society organization, you can help them draft these particular applications or pleadings. And the reason why you might want to help someone draft an application is, like it was said before, when you're drafting an application, you must tease out the issues that court ought to determine. And that is why, in terms of even looking at climate cases, some of the cases we take to court, though not defined from a climate angle, but at the end of the day, there's a climate issue that has been teased that the court ought to respond to. So ghost drafting of application is important. Again, for the second reason that if you look at attribution science in matters climate change, it is very hard to sort of get experts to actually talk about climate issues. So civil society organization can also help with getting experts from other jurisdictions, and that happened in the Save Lamu case, which Natural Justice was one of the ghost drafters in that particular case. So it's important for civil society organization to help in ghost drafting. The third one would be providing technical legal support, like I've mentioned, for organizations that have the technical expertise, like NJ. We also provide this technical legal support, come in, help you draft and frame your questions so that you can easily tease out these issues. And I've mentioned an example of getting expert witnesses to talk about attribution science. So that is another technical support that civil society organizations provide. At the same time, we also have independent redress mechanisms, which is an alternative to litigation. So civil society organizations are also keen on being part of independent redress mechanisms as provided for in some of these cases. An example is if you look at the financiers of some of these development projects, example is the African Development Bank, they usually have the independent redress mechanisms that aggrieved parties must first resort to before sometimes going to court. So even putting it out there that there are independent redress mechanisms that lawyers should be aware of is something that civil society organizations are keen in terms of taking part in. Finally, we also act as an applicant in some of these cases, because sometimes you might want to have the community out there, but in certain instances, when you go against carbon measures or the big polluters, you can be easily compromised. And I've dealt in cases whereby everyone we are fronting as a petitioner was compromised. So you have to come as an organization so that you be the face of this particular litigation. Finally, as I conclude, it's important also to involve lawyers in climate litigation cases. Climate litigation is a new subject, which importantly, as an organization, we've had the chance to organize climate training in the form of CPD, Continuous Professional Development, and we had one in August, and we are able to discuss with over 400 lawyers the global trends in litigation. And one key thing we realized from that particular discussion is that there are very many cases that are out there, and advocates are not really aware of these particular global trends specific to climate litigation. So as civil society organization, we also convene such forums whereby advocates can learn, and we specifically target young advocates who are really interested in these new global phenomena and the triple threat planetary crisis. So those in a nutshell are some of the ways in which civil society organizations can help in strategic litigation on climate matters. Thank you.
Thank you very much. Pigieni makofi tafadhali. Kwa hivyo tutaenda kwa Bwana Nyangori Oejo. Perhaps still on the same question of the role of CSOs. Anything you'd wish to add, please? You have 2 minutes.
Okay, thank you, Judge. Now, I'll not speak a lot to what my colleague has already mentioned. I think when it comes to jurisprudence issues around climate change, has already been alluded to, this is a growing area. It's still not yet crystallized. We still do not have a lot of information about it. I want to speak from a very different perspective, a minorities and indigenous people's perspective, because that is my background. And I'll start by saying that within the climate change space, climate justice space, the minorities and indigenous people's rights are yet to take root in developing decision-making around climate change investments and innovations. Now, it's always important to look at climate change from a human rights lens, because this is what it is. Anything climate impacts on how we interact with our other various rights. Anything climate will determine how we interact with our right to food. Anything climate will interact on how we interact with our right to health, and so many other rights, including the right to education. And you cannot then look at climate change without also looking at the issue of the right to land, because this is where everything is grounded. And we've just had a session where issues around land, community, land rights have been canvassed. So for indigenous peoples, it's very critical that when looking at investments, because investments, definitely a lot of them happen on lands, how do we then protect the rights of the people? One of the things that we probably need to do is advocacy and for legal reforms, and this can be done both by CSOs and the private sector. We have climate change laws. I think Climate Change Act 2016 as amended has been mentioned here quite a number of times. But there are gaps in that act. And as civil society, we still have a lot of work to do to ensure that we align that particular law to international agreements that Kenya is party to. For instance, Paris Agreement, the United Nations Declaration on the Rights of Peasants and Other Rural Workers that Kenya voted for in 2018. And even local policies like the National Climate Change Action Plan. We now have the third one, 2023 to 2027. How do these laws speak to these policies? And as they speak to these policies, how is the protection regime in those frameworks around issues of minorities and indigenous peoples collectively, as a collective, ensured? We have session of paper number 3 of 2021 on the National Action Plan on Business and Human Rights. How is our private sector providing safeguards? And how can we be able to then ensure that our legislation speaks to these kinds of sessional papers in agriculture, in energy, in transport, and things like that. So the other thing I think has been mentioned about litigations, and just slightly away from litigations and alternative dispute resolution mechanisms, is the question of cost of litigation by and large. And I think this is a subject that civil society and private sector have to work together to come around the solution. How do we ensure that some of these cases end up in court? It's very expensive to institute a public interest litigation case. It's not cheap because there are so many, even if you had a pro bono lawyer, there's so many other costs that are involved that have to be taken care of. And I think that is something that CSOs are grappling with, and private sector can come in very strongly to support in that area. Capacity building has been mentioned, not just for government, but also judiciary. And this is one example where working with the ELC, we can be able to create understanding around some of the context, some of the issues that are critical, that would then inform some of the decisions. And finally, because of time, I'll just mention that CSOs and private sector have a critical role in monitoring and accountability. We need to monitor very stringently the implementation, the commitment of government, and even the private sector to the legislative policy frameworks that inform climate change issues, to ensure that by the end of the day, human rights are at the center of every decision that we make, not investments. Should not be about profits, it should be about human beings. Because by the end of the day, every investment, every growth should be for the benefit of the people, for the benefit of everyone, including those ones who are at risk of marginalization.
This money is coming from. We are getting around 42 million. So that 42 million, we don't know 42 million of what. So I was so much worried, because why are we getting money which we have never worked for? So to me, this carbon, it's like a scam to me. Because if me as a leader, I don't understand, and my colleague chairpersons of the other communities don't understand this story, then how about that grassroots mama? And that.
But basically, your question was, how prepared is LSK in climate litigation? Because you've come late, you only have 3 minutes.
Thank you, Judge, for that. And I'm sorry that I walked in a bit late. I think the team must have been very sweet. And to start from where Mr. Sitek left, I wish I could be able to tell him that we are here. We can help you to seek an interpretation of what is the percentage that 42 million is, so that we can see whether there is justice in computation of that award that you've been given. Don't lose hope, Mr. Sitek. The Law Society of Kenya and its membership are ready to assist you to be able to seek an interpretation on the you see the question of payment is between the client and the advocate. The question of payment is between the client and the advocate. So you will leave that to me and Mr. Sitek so that we can be able to agree on how much it is. But then coming on straight to the question that has been put to me on behalf of the Law Society of Kenya, that how prepared are the members of the bar in terms of climate change litigation before our courts. And I believe this question is being asked to us from the understanding that any jurisprudence, any decision that will emanate from our courts is as good as the ingredients and the mode of presentation that is done before the judges. Any decision from a court is as good as the facts and the evidence presented before the court, also as good as the way that evidence and the facts are presented in form of pleadings and the submissions. And that then takes us to the appreciation that the Law Society of Kenya and its membership must equally be ready to be able to pursue and participate in the litigations on the area of climate justice. To start off, we have for the last 2 years, we've run we normally have our annual conferences. Of course, some of you might know it as the Diani conferences that we normally have at the Law Society of Kenya. Of course, some of you would call it the annual migration that we normally have. For those two conferences, for the year 2023 and 2024, climate change has been part and parcel of the discussions that we've been able to have, so that then our members can be able to come up to speed to appreciate that climate change is no longer an abstract phenomenon. It's now a reality with our people. It's a justiciable issue before our courts, and now we need to prepare ourselves to be able to assist our clients, the litigants, and also assist the courts in administering justice in that area. So we have started that discussion, Judge, as the Law Society of Kenya. Of course, building on that, we have also our continuous professional development program, what we call the CBDs. Part of the CBDs that we've arranged for the last 2 years are also on climate change. And that, of course, will focus on litigation, how advocates can effectively participate on litigation with respect to climate justice. So as advocates, we are preparing ourselves. Of course, we can, is happening in a neighboring country. And we may need then to bring the regional bodies. Of course, for the Law Society of Kenya, we have the East African Law Society, we have the Pan-African Law Society that can then be able to bring all the lawyers to be able to think through on how, as a region, we can be able to build on resilience in terms of litigation and to assist our communities to mitigate the effects of climate change. The other issue is that in terms of the inadequacy of our jurisprudence,
Thank you, Judge. I don't know if it is plans as Benson, or plans as a teacher of law, or plans as an environmental lawyer, but let me assume, anyway, we were classmates. That's one of my claims to fame. I work for an organization called the Institute for Law and Environmental Governance. I believe that it could be in that context. The Institute for Law and Environmental Governance, in a sense, was a pioneer of judicial training in Kenya. And I remember at one of the judges training, those days you were not calling them judges training because judges knew it. How could you train them? You remember those days of Justice Kwach and Omolo. Yeah, so when we organize events of this, cannot be left to chance. And JTI, then the precursor of the Judiciary Academy, came into being. And we've remained loyal to the cause every time. We've remained loyal to the cause every time an opportunity arises. We engage with like-minded institutions like UNEP and the Environment and Land Court. In terms of plans, therefore, Bwana Moderator, Yes, we continue the course, and I believe we've been discussing with the presiding judge of ELC and with Judge Anomolo, heading the Environment and Planning Division, on how we can integrate some of the work that we've done, and particularly as we veer into these new areas of environmental litigation, like climate change, ICT, and stuff like that, we could integrate all that. In addition to that, we have also been discussing considerably with the Judiciary Academy, and I know that Justice Smokin Wanjala has been very keen on strengthening partnerships and particularly paying keen attention to these evolving areas of environmental law like climate change, and particularly in the area of advancement in technology and biotechnology and stuff like that. So there are plans underway, and I believe we are going to concretize this as we move along. And we've also organized training for lawyers, because as the chair said, it takes two to tango in this business. And if we don't have well-capacitated lawyers to present the cases, the judges can only do so much, as they are doing right now, but it could be strengthened. So it will take all legs of that stool to stand. Thanks a lot.
Asante sana. So I'll give the panelists 2 minutes each for parting shots. We start with Mr. Onyango. 2 minutes.
Thank you very much, Judge. I'll start by quoting Lord Denning in Nyali Limited versus Attorney General in 1957. And he said, you cannot uproot an English oak and transplant it to contextualize in Eldoret without pruning it and watering it. And he was referring to the English common law. And the same thing applies to climate litigation. As lawyers, as judges, we cannot just take what is happening in the global north and transplant it and want it to actually have the same force and effect, considering that we are a country that still wants to rely on the loss and damage fund. So we must know how to engage our government to actually actualize climate litigation. So the aspect of contextualizing our cases, even as we borrow, so that would be a great parting shot for me.
Mr. Ohejo, parting shot.
Thank you, Judge. I think for me, I'll start by saying that we still have work to do with regards to developing jurisprudence around climate change and minority indigenous people's rights in Kenya. The rights of minorities and indigenous people is still a new concept in our country. 2010, so many of us still do not have not grasped it fully. We've been, as an organization, the Center for Minority Rights Development, worked on this for the last more than 20 years, since we established in 2001. And one of the things that we've done is that we've been at the forefront of developing jurisprudence around the issue of minorities and indigenous peoples. Recognition is there today, so where we need to move towards is to have jurisprudence around how do we actualize these rights as provided for in the Constitution. We are closely working with the Environment and the Planning Division. We are members of the working group. We've participated together with the division in a number of activities. And we hope as we progress on this and calling upon our partners that we've worked with previously, that we'll be able to work with all the stakeholders, both our partners in civil society, the private sector, and the judiciary, to be able to understand and locate the
place of minority and indigenous peoples in climate justice conversations, and ensure that, as my colleague was saying here, that communities are not taken advantage of. In many of our communities who identify themselves as minorities or indigenous peoples, land and environment are critical to their survival. And therefore, when we talk about investments, that is why we have the business and human rights sessional paper right now. When you talk about investments, there must be safeguards. But the question has always been, who are these communities? This is clearly defined in the, given out in the Constitution. However, we need to then context that will enable us to be able to interpret these rights within very specific situations and ensure that where decisions are being made, those decisions are being made for the benefit of these communities. Thank you.
Thank you. Thank you very much. Mr. Sitek, the man in the room. Yeah?
Thank you. That we have found a place that will rescue us, the LSK. This, when it comes to climate change, the climate change is real, and it is affecting our peoples. Last year, not last year, 2022, nilihamisha ng'ombe yangu pande ile ya Umruti, for those who come from Laikipia, during the prolonged drought. Prolonged drought is one of the effects of the climate change. Na wakati nilienda huko, niliambiwa na chocho of around 80 years, do you know why we are suffering? I don't know. She told me, because kuna watu waliuza hewa yetu. Na kwa sababu I was one of the leaders to be blamed, I was guilty of myself. Because hata singejua nitamjibu aje. So the climate change is real, the prolonged drought we are experiencing. That leads to scarcity of water, scarcity of pasture. And because of those reasons, the banditry, wizi ya ng'ombe, has significantly gone high from where I come from. So we are being affected. Na watu wanasema kwa sababu ya hii story ya carbon. So also, from where I came from, because I am a person who speaks what he sees and he speaks his mind. From where I came from, government is doing nothing about that. Nilikuja hapa nikasikia kitu inaitwa floka. Na huko nasikianga tu. And it is something, wakati nilikuja kuelewa kidogo, nilielewa kama it is devolved. It is not working from where I came from. Maybe it is working in other parts of the county. But from where I came from, it is not working. Thank you so much.
Thank you very much, Mr. Steck. Information sharing. It is important you know there is Access to Information Act. It's also a right under Article 35 of the Constitution. But you found the Law Society are ready to help you, but for a fee. Now, my Lord Justice Okong, you have 3 minutes to give your parting shot.
Thank you, moderator. I did some comparative analysis of our court and the courts, the best environment and land courts out there. I also looked at the regional, the East African courts, the East African community, and I found that they are all doing something on climate change. I found that Uganda has a National Climate Change Act. I discovered that Tanzania was ahead of us. They have climate change carbon market regulations 2022. Ours was 2024. So there's a lot of activity in the region. In terms of cases, I think we are the same. I was not able to get any climate change related case in the region, but I think they are laying a very good legislative foundation in this area of climate change. So as judges, there's a lot we can actually borrow from the region. I noted that even the East African community has a protocol and has a policy on climate change. So those are some of the instruments we can actually apply and resort to when we are developing jurisprudence. Again, I considered courts like New Zealand, Philippines. I noted that they have very flexible rules of procedure. And again, they are very, very, very flexible on remedies that they can give. I think that is something we may need to have a look at. We may need as a court to work on our rules and factor in, and tie our hands when it comes to remedies we can give and the procedure. We can also have a relook at our ELC Act. There was a provision in it that allowed us to call in the experts. Climate change is actually, to some extent, science. So there are a lot of experts out there we can use. And I think that would only be, we'll be able to do that if the amendment, if we amend our act and bring back the provision that allowed the use of experts. Again, we should not shy away from, when we need to give a remedy, let us give a remedy. There has been a cry out there about, judicial activism. I think in the area of climate change, we may have to go out of our way to make suitable remedies where they are necessary. Thank you very much.
Thank you very much. Judicial activism. All right, Henry, do you have anything? You have 2 minutes.
Thank you so much, Judge. I think all of us, in closing, is for me to say that for a long time, discussions on climate change have been from an abstract level. And people have not been relating to it because of that abstract discussions. But now I think we need to bring it home, let the discussions on climate change be simplified for everyone to understand, considering that climate change is a global disaster as we speak. It needs then everyone, all from the most sophisticated of our citizenry to everyone down in the villages should then be able to understand. And I believe the judiciary, the Environment and Land Court would be a key plank in ensuring that we are able to debunk these sometimes mysterious nature of climate justice and the discussions on climate change. And of course, that then will allow me to pick from where my Lord Justice Okong has left in terms of being versatile as a judiciary in interpretation and on dealing with matters that come before the courts on climate change. And I believe we have an opportunity as the Environment and Land Court in Kenya to be a trailblazer and to be able to set the pace for the region. Allow me to also thank our judges for the good work that you are doing. For the last 10 years or about 12 years now, I believe the Environment and Land Court has done quite a lot to ensure that we are able to protect the land and environment rights. A new challenge has come as you turn to the new decade in terms of the operationalization of the court. I believe that this is a beautiful time to be a member or to be a judge in the Environment and Land Court and to be a participant in that court, because a new challenge has been thrown to us that we need to be able to assist the country and the world in debunking this issue about climate change and assisting our communities to be able to protect themselves against the devastating effects of climate change. And I believe if we are versatile enough, we should be able to create the momentum for the need for amendment of the law. When you read the Climate Change Act, I believe it's too broad on issues that are not very necessary, but then it's too short on issues that are very important. When you look at the definition of climate change under our act, I believe we just borrowed straight from what the United Nations say, but we are not appreciating how climate change should be broadened in terms of the definition, so that everyone plugging into the climate justice will be picking from a broad perspective, so that all the issues that would arise from climate change can be addressed. Otherwise, I want to appreciate that this is a good starting point of having such a conference, but let us keep the discussion going. May God bless you.
Asante sana, na kwa hivyo nitarudisha usukani kwa mwenyekiti Judge Linet. Where are you? Where are you hiding yourself? Asanteni sana.
Thank you very much to all the panelists and the moderator. I think we all agree that this session has been extremely thought-provoking. We have learned a lot, and I think we're a lot more knowledgeable than when we came in. I think we have plenary. I know that we were told we need to wrap up this session by 1 p.m. I think we can take a few questions from the plenary, maybe 3. I know that we are pressed for time. I can see 2 hands up, and I will 3. Allow those 3, 4, and that's it. We can start with Justice Cherono here. Keep it short and sweet, please. No, we can't. Kindly pass the mic.
Yes, thank you so much, speakers. And I want to appreciate my lecturer who taught me before I ran away from school. Dr. Yes, I want to raise 2 questions. My question goes to Judge Okongo. We have this National NCHA, National Council for Administration of Justice. It has devolved its functions to the CUCs. I heard from one of the speakers, he talked and said that you have to contextualize each and every climate change. Now, what is happening in Baringo for the judges who are working there is not the same as what is happening in Kisumu. So is it possible that you can be able to, we can use leverage on court users committee so that we can understand what is happening on the ground, so that when the cases come, like KBJ Kosibor judge, she was, I have seen you are one of your members are here. So that we can be able to understand what is happening there, and we are able to educate these people so that any cases which are coming to us for adjudication, we are well enlightened. The second issue is this...
Judge, I will only allow you that one.
Okay.
Thank you.
Thank you. My name is Collins Kemboy. I just want to go straight to LSK, as you had said previously, how you are going to assist the community. My concern is this, and I think it's a concern for all of us, that the question that is in mind is that the 1.9 million that Mr. Seka has already, acres, 1.9 million acres, equivalent with the 42 million, with the population that is within that area, is not real. And it's a big question that IENA already is in the society, eating the vulnerable. So this is the high call, LSK, you take lead to overfast the pro bono public litigation support. In that, I believe it will start to build the grounds, and Honorable Justice Simon has just said, that, yes, Okong, just compare the Uganda and the Tanzania, who have already ahead of us in terms of bills. So my concern is just let's set the pace and let's come through to assist.
I think that was a comment, am I right?
Yeah, comment. And
Thank you.
concern.
Justice Kosibor here, please.
Thank you very much. Mine is more of a comment. I think Advocate Kene, when you mentioned about Uganda being ahead, I also wanted to add that there's another advantage they have over us. They actually have nature rights in their law. So the environmental law incorporates nature's rights. And I think that's the next conversation, Dr. Ochieng, that you will be leading, because if we also give nature rights, the forests and all the other aspects of nature, then that might be one of the ways of of handling the issue of climate change, biodiversity laws, and the others. So that's what I was going to say. And then the other problem we have, it is good to talk about climate justice. Beyond where the courts will have made decisions, we still have a challenge in terms of enforcement. So it is one thing to have my person from Laikipia go to court, get a court order. We work very hard as judges. We give orders. After that, they are not enforced. So we also need to look at the enforcement of the court orders. Thank you.
Thank you very much. Now that we have two comments, I'll allow that last one and no more. Thank you.
Thanks. Mine is a comment. My name is Washira Kariuki. When you look at environmental litigation, 3 ways that they are bringing themselves out. And in this country, we are lacking in one area, that is enforcement litigation by public agencies. There are public agencies that have the mandate to take care of our environment, and they need to take our position on enforcement litigation by public agencies. For example, NEMA should be able to do that, NEMA, the Kenya, and also the Land Commission. The other one is litigation between private parties themselves, where somebody is suing for maybe somebody else is blocking light or such things. And the other one is private action against public agencies themselves. And that is something that we need, when it comes to court, let the judges look where is the dispute. Is it between enforcement litigation? Is it between private, or is it a private telling the agencies to do what they need to do?
Thank you very much. I think Justice Okongo, there was one question directed at you.
My brother, I believe I got your question right. It was whether we can use the court users committees to know what is happening in various parts of the country. I doubt whether that would do, because these committees were actually formed to deal with local issues, because each part of the country have unique challenges, unique issues, which the court users committee or the members of court users committee in the particular region or particular area should be able to meet, exchange ideas, discuss, and address those unique emerging issues. But still, I think, of course, as judicial officers, as judges, we have various forums through which we can actually exchange ideas and share, on what is happening in various parts of the country from where we operate. Otherwise, I don't think the court users committee would not do. Thank you.
I think the panelists have done justice to that topic. Let us give them a round of applause as they take their seats. All the way to their seats, you're free to step down. Thank you. As they do that, I will hand over to Moderator General. That's the name I have given her. Thank you very much.
That's a good one. I'll add it in my CV. Thank you very much. Thank you very much. Session 10, are we here? 10. This was 9, right? Ben, are you here with your team? So thank you very much for that very good session. I think it was solid. Maybe we should give them another hearty round of applause. We have had 3 very solid days with solid conversations. Don't you agree? Let's clap for all of us. So let's clap for all the panelists, all the moderators, all the chairs for the week. Can I have Ben Opa give us the highlights, just 2 minutes? Oh, you're here. And then I'll give it to Honorable Zili to also give us 2 minutes highlights. Although you are here, I think all the others also need to hear. Just go to the other one. Just 2 minutes, because we want to break for lunch in the next 4 or 5 minutes.
Yeah, so good afternoon. My name is Ben Opa. I was moderating session 10, which was basically focusing on capacity building for the climate change justice delivery. And we have just finished our session. A number of issues are coming out from that. Number one is that there are glaring capacity gaps across the board. The judiciary has capacity gaps. The stakeholders, including the litigants, are also having capacity challenges, in particular for climate change pleadings and litigation. The communities themselves also have capacity challenges in understanding and appreciating climate change and the vagaries or impacts of climate change, and so that also impedes that. That also impedes the delivery of climate justice. The other issue that is also coming out in regards to capacity is the conflicting jurisprudences between the ELC court and also the Court of Appeal, because we've noticed that ELC is more specialized and has more technical expertise on land and even environmental matters. However, the Court of Appeal may not have that, so sometimes the jurisprudence is not sustained. The jurisprudence from the ELC is not sustained when it is challenged at the Court of Appeal. That is a major capacity issue in regards to the delivery of climate justice. The other issue that was also coming out is the lack of a proper compendium for the judges particularly, to have a glimpse, a very quick glimpse of the issues around climate change. And so one of the recommendations that is coming out is for the need for the Kenya Law Reform to support and help the judiciary to establish a proper compendium or a comprehensive capacity building program, starting with a compendium for specific topical issues around environment and climate change. We also noticed that land is given higher premium as an important asset, but relegating environment and climate change matters and the rights to that at the peripherals. So some of those issues require capacity building, and we have discussed and agreed that there is need for a very robust yet versatile capacity building program across the entire spectrum of stakeholders, including the judiciary, along all the way to the Supreme Court. I thank you so much for the time. Thank you. Over to you.
Let's clap for him. Thank you very, very much. I think 4 key issues: capacities, conflict of laws. Maybe we need to start thinking about auditing the laws and then just addressing those, a compendium of laws. Land, why do we put a lot of premium on land in Kenya? I think the judges will tell us one day. I'm sure in your rulings now, by now you know. Thank you. Chair, please take us through your highlights of your session.
Our sub-theme was local, regional, and global judicial trends in climate litigation and jurisprudence. We had a very knowledgeable panel, and they took us through what is happening locally, that is in our country, regionally, that is in East Africa, and globally. The first question was posed to Honorable Justice Okongo, and he said that as a country, we are ready to work towards a robust jurisprudence on climate change issues. He says we have a framework, for example, the Environment and Land Court Act. We also have the Constitution of Kenya 2010, which has given us a right to a clean and healthy environment. We have the framework legislation, that is the Environmental Management and Coordination Act. We have the Climate Change Act. We have the Climate Change Act. We also had from another speaker, and he asks what we are doing in climate change litigation. And he says that climate change litigation is still a mongrel that hasn't been defined adequately. And he asks questions like, where do you file climate change cases without being treated as a different case? He talked about right to access justice, legal standing. Environmental litigation is yet to acquire its legal standing that is precise. Climate change issues surround issues to protect life and livelihoods. And to that extent, we still have a long way to go in terms of climate litigation in Kenya. It is growing. We are on the right path, but we don't have a lot of litigation in our courts on matters of climate change. We also had from another speaker on community, he's from a community land management, and I must report that he stole the show here today. He was giving us real life experiences as regards bargaining for these projects that are intended to reduce carbon in the environment. He tells us that these agreements have been signed and some money has been given to communities, but he doesn't know what percentage of that amount, the 42 million that has been given to communities, is about. We also had from the Law Society of Kenya and other civil society organizations speaking to the role of civil society in climate action. And they say that climate litigation is complex, and it is not just about going to court. You must ensure that you have drafted your pleadings properly and that you have presented your case well so that you have favorable outcomes from the courts. So we had a speaker from Natural Justice East Africa Hub who has experience in strategic litigation, and he gave us useful insights on how that is done, and they're ready to help advocates, young advocates who might be interested in strategic litigation. We also had Law Society of Kenya, who refused to commit to doing these cases that might come up pro bono. They say that is an issue between them and the clients. But by and large, they applaud the court for the work that it has done for the last 12 years. And I think we need to clap for the Environment and Land Court judges for the good work that they're doing. And he says that he gave an example of the Climate Change Act, which he says speaks broadly on issues that are not very important to us and very little to the issues that are important to us. So he says that even as we deal with matters climate change, we need to localize them so that they represent the lives that are lived by Kenyans. I think I will leave it at that, but that gives an overview of the discussions that we had in our group today. Thank you.
Thank you very, very much. Enabling legislation exists. We need to do some alignment, but also one other issue on localization. Think global, but let's speak to localization. And with that, before we go, I want to ask that Honorable Wamwaro sees me before you take off for lunch. PJ, how many minutes do you give us for lunch? It's now 1:23:45. Can we meet here at exactly 2:15? Our chair, I consider you our running chair for the week. from the conversations from Monday to today, just one thing, it's just my observation and my very wild thoughts. Last year, we facilitated a session in Malawi where all ministers for health and environment in Africa came together to put a common position for Africa on climate and health, so that the issue of health becomes a running theme in any conversation in the United Nations framework on climate change. You might want to think about that. If we have to move and showcase what we do, because I've seen a lot of thought processes going into the work that we do, the 3 days showcase actually what good work we are doing in the 47 counties are critical. It could be that you put together, and it could be a brainchild of the Kenyan ELC, put together the Africa judges on land and climate, and see to it that you actually champion it conversation. Because Odengo was here yesterday saying, oh, he will take 1 or 2 or 3. And I think His Excellency, the Judge, Smoky Wanjala, took up that challenge quickly. He should be the first plane, I think, to Austria. But I think my challenge to you is we can begin thinking about that conversation. And I'm sure you'll make a mark on it. Thank you. Let's have lunch. Let's meet at 2:15. Thank you very much. And thank you for being very good audiences, by the way. Thank you very much for the patience. Let's have lunch and let's meet at 2:15. Here. Honorable Wamwaro, I want to see you before we go. By the way, yesterday we had 3 judges that were not in the, you remember the video? Yes, the ELC book of Genesis and Revelations. Ilikuwa gani? Yes, we would like to see that as we go. Our media people, can you have that running? We'll run even as we start, so don't worry. There are only 3, so you have all the time. We'll run that. You can run it.
Tulikuwa vijana, tulicheza na masomo, kazi ya watoto, kweli kila siku ni kucheza. Tulikuwa vijana, tulicheza na masomo, kazi yao, kweli kila siku ni kucheza. Someni vijana, muongeze pia bidii, mwisho wa kusoma mtapata kazi nzuri sana. Someni vijana, muongeze pia bidii, mwisho wa kusoma mtapata kazi nzuri sana. Waliokosa kusoma wafanye kazi na nguvu, kwa mtoto mwisho wa kusoma kwe. Tulicheza na masomo, kazi ya watoto, kweli kila siku ni kucheza. Tulikuwa vijana, tulicheza na masomo, kazi ya watoto, kweli kila siku ni